Sydney Joy Steele, okay, you're charged with following too close on 2024 TK 06653. You're also charged with improper lane change on case 2024 TK 06652. Mr. Tipton, are you ready to go forward with trial?
Yes, Your Honor. State's going to call Lieutenant Jonathan Carey to the Zoom call.
All right. Lieutenant Carey, raise your right hand for me. Do you solemnly swear or affirm any testimony you give in this matter will be true? All right, you can put your hand down, sir. Ms. Steele, you understand that you have the right to ask questions of any witnesses brought by the state. The state has the burden of proving the case against you beyond a reasonable doubt. You do not have to give any testimony or evidence against yourself. You have a Fifth Amendment right against self-incrimination, and the state needs to prove the case beyond a reasonable doubt. All right, do you understand?
Yes.
All right, Mr. Tipton, you may introduce your witness.
Yes, Your Honor. Lieutenant Carey, please state your name for the Zoom call.
Lieutenant Jonathan Carey.
And Lieutenant Carey, how are you currently employed?
Currently the lieutenant for the Clayton County Sheriff's Office Black Hawk Traffic Unit.
And how long have you been with the Clayton County Sheriff's Office?
The Sheriff's Office, probably a little over 2 years.
And you have prior experience before that, correct?
Yes, I was with the Clayton County Police for about 4 or 5 years.
Okay. And during that time, both with the Sheriff's Office and the police department, have you been post-certified?
Yes.
Okay. And being post-certified, are you authorized to investigate crimes, issue citations, and make arrests based on your investigations?
Yes, I am.
So I want to bring your attention to March 20th of 2024. Were you working for the Clayton County Sheriff's Department at that time?
Yes.
And were you on duty that day?
Yes, I was.
Did you at any point in time have occasion to make contact or initiate a traffic stop with a white Chevrolet Trax that was driven by Miss Sydney Steele?
Yes.
Okay. Can you tell me about what drove you to or what caused you to initiate contact with Miss Steele?
Yes. So during my role during the day, I look for erratic lane changes, reckless drivers, speeders. So while traveling on Fair Boulevard, passing over 48, I was monitoring traffic in my rearview mirror. I observed a white SUV changing several lanes, not giving the public enough notice that she was changing lanes, nor was she using a nor was the vehicle using a turn signal. I observed the vehicle getting closer to me as she was changing lanes. She was also following another vehicle too close. Once she changed from lanes 2 back to lane 1 several times, she passed me. I'm sorry, from lane 3 to lane 2, she passed me in lane 3. And that's when I conducted a traffic stop on that vehicle and spoke with the driver. While speaking with the driver, she advised that she was in a hurry to get to Atlanta because she had a hair appointment.
Okay. You say she didn't use any turn signals. Is that correct?
Correct.
Okay. And what was the basis of the following too close?
She was following another vehicle too close as she was changing lanes.
Based on your knowledge, your training, and your experience, as well as what you observed, was that a safe maneuver for her to make?
No, it was not.
Would a reasonably prudent driver have followed that closely?
No. And if that vehicle in front of her would have slammed on the brakes, she would have been at fault, and that definitely probably would have caused an accident.
Okay. And with the improper lane change, was there anything improper? Tell me about what was improper about that lane change besides just the signal.
So when you change lanes, you have to give the public enough notice that you're about to change lanes, which she failed to do.
Okay.
Several times, not just one time.
Okay. So about how many lane changes did you observe?
I believe I observed 3. So she went from the number 3 lane to the number 2 lane, then back to the number 3 lane.
It's occur in Clayton County?
Yes, it did.
Okay. I have no further questions at this time.
All right, Ms. Steele, did you have any questions of Lieutenant Carey?
Yes.
Go ahead, ma'am.
So you said that you were observing me in your rearview mirror when I
Correct.
did all of these okay. So if you're observing me in my rearview mirror, how are you able to see how close I'm driving behind another car? If you're looking in your rearview mirror, you would see the car that's in front of me. You wouldn't be able to see my car.
I can see your car and the car in front of you.
Got you. So how are you able to determine how close my tires were to the trunk of the car in front of me?
I can't determine how close your tires are, but I can determine how close your bumper is to their rear bumper.
And how are you able to do that?
By looking at it.
And what did you see? How close was I, if you had to guesstimate?
You're less than a car length behind him.
Less than a car length?
Correct.
And this was another car and this was not your car?
Correct.
Okay. I don't have any more questions for you.
Lieutenant Carey is questioned by Assistant Solicitor General Tipton, and then Miss Steele gets the chance to cross-examine him. Lieutenant Carey asserts that throughout the inspection, he was able to observe in his rearview mirror how closely she was behind another automobile and that she was less than a car's length behind it. The Georgia Code's Section 4649 prohibits drivers from following another car, quote, closer than is fair and sensible given the speed, traffic, and road circumstances. The Court of Appeals of Georgia ruled in the 2009 case of Proctor v. State that an officer had the right to stop a car for following too closely when he saw a driver on an interstate highway about a car's length away from the vehicle in front of him. Based on the speed and traffic conditions, the officer concluded that the driver could not have avoided a collision if the leading car had broken abruptly. Therefore, it may be possible to prove that Miss Steele committed a traffic infraction by following the automobile in front of her too closely based on Lieutenant K's evidence that she was less than one car length behind it.
All right, anything else, Mr. Tipton?
Briefly, Your Honor. Lieutenant Carey, was your view of the car immediately in front obstructed?
No.
Was your view of Miss Steele's vehicle obstructed?
No.
Which lane were you in, sir?
I was in the number 2 lane.
Okay. And which lane did you observe the vehicle in when it was following too close?
Number 3.
Okay. Would you say that?
No, well, when she was falling too close, she was in the number 2 lane as well.
Okay.
She went from number 3 lane to the number 2 lane, followed the car too close, and then switched back to the number 3 lane.
Okay. Was there were there multiple cars that she followed too close to, or just the one?
Just the one.
And so you had an unobstructed view of her front bumper and the rear bumper of the car immediately in front of her, correct?
Correct, by using my side mirror at the time.
Okay, awesome. Thank you. No further questions.
All right,
I do have just one more question.
go ahead.
What was the kind of car that I was driving behind?
I'm not sure.
Okay.
Lieutenant Carey is redirected by Assistant Solicitor General Tipton after Miss Steele has finished her cross-examination, and after testifying that he spotted them with his rearview mirror, he now claims to have seen Miss Steele's bumper and the bumper of the car she was following with his side view mirror. Lieutenant Carey is then asked by Ms. Steele what kind of car she was supposedly following too closely. Lieutenant Carey also acknowledges that he is unsure. By getting Lieutenant Carey to acknowledge that he was unsure about the kind of car she was purportedly following, Monsieur Steele's interrogation seems to be a deliberate effort to highlight flaws in Lieutenant K's evidence and throw doubt on the veracity of his accusations. Miss Steele went on to say that his memory may have been fabricated after the event or was untrustworthy.
You remember the color?
No, I don't.
Okay. I don't have any more questions.
All right. Did the state have any additional witnesses to present?
No, Your Honor. State's going to rest at this time.
All right, Ms. Steele, did you wish to present evidence and testimony?
Yes.
All right, you understand that you're not required to present any evidence or testimony?
Yes.
All right, you're waiving your right to remain silent in order to offer evidence and testimony?
Yes, ma'am.
All right, raise your right hand for me. You solemnly swear or affirm any testimony you give in this matter will be true?
Yes.
All right, you can put your hand down. Go ahead, tell me what you need me to know.
Okay, so the day this happened, I stopped at the gas station. At the time, I was 6 months pregnant. I stopped at the gas station, grabbed some water. I get out of the gas station. I turn right. As soon as I turn right, I turn into a light. I pulled behind the police officer. No other car was in front of me other than the police officer. When the light changed, it's like he wasn't moving. So I put my signal on to get in the lane to the right of me. I got in the lane to the right of me. He then got in the lane behind me. And I looked in my rearview mirror and I'm like, he is driving so close to me. Like, he was so close. I could not see his tires. This is why I asked these questions, because in driver's training, they teach you have to at least be able to see the car's tires behind you. So that's how I was able to determine that he was driving too close to me. It was not a car length behind me. So then I'm like, okay. So I put my signal on, get back in the left lane. He gets back in the left lane. So I'm like, what is happening right now? Like, I was so confused as to what's happening. I'm like, am I in his way? What's going on? So then I did get back into the right lane. And when I went to get into the right lane, that's when he turned his light on and pulled me over. And I was confused as to one, why he chose to do that. Because I was, like I said, I was just confused. And he asked me, I asked him, why did you pull me over? And he said, are you in a hurry or something like that? And I was like, well, I'm trying to get to my hair appointment because I was going to get my hair done for my baby shower. And he's like, okay, and then asked for my information. And when he came back and told me, one, driving too close, I'm like, how was I driving too close when I pulled up behind you at a red light? So I literally was not driving. You weren't driving. The light was red. And then when the light changed colors, you didn't really take off. So I'm like, okay, let me get out of this man's way because I have somewhere I have to go. And clearly he does not. So that's when I got over. And also, I have a 2024 Chevy Trax. My car, you literally cannot switch lanes without putting your signal on because it will jerk you back into your lane. So for one, I don't change lanes, especially while I was 6 months pregnant, without giving anybody proper notice because I wouldn't want to put myself or my son in danger. And then that's why I also asked, what was the car? Because, there literally was not another car in front of me other than him. And then when I got over, for him to see all of these different lane changes, he was right behind me. And I did switch lanes that many times because he was driving so close up on my bumper to where he was correct. If I would have put on my brakes, he would have hit me in the back of my car.
Okay. Any questions, Mr. Tipton?
No, Your Honor.
All right. Anything else, Ms. Steele?
No, ma'am. No, Your Honor.
Okay. Argument?
State will submit on the facts, Your Honor.
All right. Ms. Steele, I found you not guilty of the offenses before the court. Each of you are given testimony in this case. Each person has submitted sworn testimony without additional evidence. Neither testimony has greater weight than the other. Therefore, the court is not able to determine beyond a reasonable doubt that you committed an offense in this case and finds you not guilty on both offenses.
Thank you.
You're welcome.
Judge Hayward finds Miss Steele not guilty of both counts after she provides testimony that differs significantly from what Lieutenant Carey alleged had happened. Let's now examine another pro se defendant whose hearing resulted in a very different conclusion. Trevor Mloud, a defendant from Michigan, was charged on September 3, 2023, with refusing or obstructing conservation officials, a felony, and driving a watercraft while drunk, a misdemeanor. 2 days later, he was charged and freed on bail. Following an initial review, the matter was transferred from District Court to the 53rd Circuit Court in Spohn County, where Judge Aaron Gokche was given the case. On December 19, 2023, the court set a pre-trial hearing and arraignment. Additionally, Mr. Mloud chose to represent himself throughout the process.
Understand your right to a lawyer, including a court-appointed lawyer?
I understand that.
Okay. And do you wish to represent yourself instead of having an attorney?
Yeah, I'm here by special appearance, and I will be representing myself.
I'm required by law before I accept that waiver to do a couple things. One, advise you of the maximum penalties that you could face for the charges that you're in my court for. Resisting obstructing conservation officers is a high court misdemeanor punishable by up to 2 years in prison and or $1,000 fine. There's a habitual offender second notice that's been filed by the prosecutor, which would make that a felony punishable by up to 3 years and or $1,000 fine. And marine safety operating while intoxicated is a misdemeanor punishable by up to 93 days and or a $100 to $500 fine. Do you understand the maximum penalty for the charges against you?
Well, I don't even really understand why I'm here, honestly.
Well, okay. Well, that's fine. Do you understand the maximum penalty that I just explained to you?
No.
Hold on, I can't let you represent yourself until I establish a couple things.
Well, I need to establish a couple things too, honestly.
Hold on, well, I can't let you represent yourself until I establish a couple things or I'm going to be in trouble. Do you understand that the maximum penalty that you could face for the charges that you're here for is up to 3 years in prison and or a $1,000 fine?
I don't understand the nature and cause of the action against me, so I guess.
What is it that you don't understand? Do you not understand how long 3 years is, or how much the fine is that I've articulated? Can you tell me what
I
it
don't
is you don't
understand the
understand?
nature and cause of the action against me because we don't establish jurisdiction.
That's not what I'm asking you right now. Well, I'll let you place whatever objections you want on the record, Mr. McLeod. I promise you that, okay? Can we just go one step at a time? So do you understand the maximum penalty that you could face if you're convicted as charged? 3 years in prison or $1,000 fine?
Well, I have another question because the statutory jurisdiction doesn't exist under the Constitution. So in order for me to defend myself, could you please tell me where the published rules of conduct are for criminal statutory jurisdiction, or where I can find the nature and cause of this jurisdiction, or how this information exists?
No, I don't even understand what you're asking.
So you're saying this is a statutory jurisdiction under what? The statutes of Michigan, correct?
Mr. McLeod, I've told you what my jurisdiction is.
General
The
jurisdiction.
people of the state of Michigan voted to convene a constitutional convention in 1961.
Sure.
There was a constitutional convention in 1961 and 1962. They proposed a state constitution. The voters of the state of Michigan ratified that in 1963. Article 6 establishes the judicial power, and the circuit court is a court under that judicial power of Article 6 of the state constitution. And so you're here in my court. I have subject matter jurisdiction over those crimes. I have personal jurisdiction over you because you've been alleged to have committed them in our county. That's my jurisdiction.
Mr. Maloud questions the court's unquote jurisdiction. Additionally, Judge Gocher clarifies that the Michigan Constitution and state law provide the court both quote-unquote subject matter and quote-unquote personal jurisdiction. When Mr. Maloud questions the court's jurisdiction, in essence, he is claiming that the court does not have the legal right to hear his case or render legally enforceable rulings against him. Generally speaking, a court can only handle a matter if it has been given jurisdiction by a legislation or the Constitution. The ability of a court to hear the kind of lawsuit that has been filed is referred to as subject matter jurisdiction. A criminal prosecution under Michigan law in this case. In Michigan, circuit courts are courts of general jurisdiction, which means that, with the exception of matters that are expressly designated for other courts or the federal system, they have the wide power to consider civil and criminal cases originating under state law. Conversely, a court's authority over a specific defendant is referred to as personal jurisdiction. Since Mr. Maloud was duly presented before the court and the alleged violation took place inside its borders, the 53rd Circuit Court has personal jurisdiction over him. As a result, Mr. Maloud's claim that the court lacked jurisdiction was illogical.
So, Mr. McLeod, you want to represent yourself? Do you understand the maximum penalty that you could face of 3 years in prison and or $1,000 fine?
One second.
I can see why his attorney withdrew. Oh, shit.
Hang on. Someone in the prosecutor's office is not muted. I'm going to remove you from the meeting at this time.
Oh,
Prosecutor's office is generally allowed to attend to observe. They've participated. I'm removing them from the hearing. Mr. McLeod, do you understand the maximum penalty that you could face?
1 second. Okay, so in enforcement of mere statutes, judges of all courts do not act judicially and are thus are not protected and qualified by limited immunity. And that's Owen versus the city. I just want to state a few things for the record since you're claiming this is a jurisdiction under statutory law.
Hang on. Mr. McLeod, can we back it? Look at me for a second. Can we talk here?
I've challenged subject matter jurisdiction and nothing can go forward until that's addressed. You're saying
I did address it and I denied your objection. I have subject matter
jurisdiction doesn't
jurisdiction.
exist under the Constitution.
Your objection is noted. So, Mr. McLeod, do you understand? Let me explain to you.
Sure.
Sometimes, as I said, people might want to represent themselves, but let's say they have limited intellectual capacity and they don't understand what's going on. I have to establish that they know what's going on before I can allow them to represent themselves. I'm required to establish, do you comprehend, do you know the maximum penalty that you could face if you're convicted as a result of this charge? 3 years in prison or $1,000 fine. Do you understand that, Mr. McLeod?
So I'd like to state for the record that
Mr. McLeod, stop.
court can be.
Stop, Mr. McLeod. If you don't understand it, I'm going to revoke your right to represent yourself and have an attorney represent you because I can't establish that you know what you're doing. So do you know the maximum penalty that you would face?
Judge Gocher keeps asking Mr. Maloud whether he is aware of the potential punishment in the event of a conviction, but Mr. Maloud won't respond. Judge Gocher then informs Mr. Maloud that if he does not comprehend the matter, he may withdraw his right to self-representation. The Supreme Court ruled in the 1975 case of Ferretta v. California that criminal defendants have a constitutional right to represent themselves in court if they knowingly, intelligently, and voluntarily give up the customary advantages connected with the right to counsel. As we have previously discussed here on ATC and on our other channel, Audit the Audit. This served as the foundation for Judge Gocha's interrogation of Mr. Malaud, since he had to be sure that Mr. Malaud was rationally, willingly, and intentionally waiving his right to counsel after fully comprehending the potential consequences of the allegations against him. Therefore, until it was determined that Mr. Malaud's renunciation of the right to counsel was a fully informed choice, Judge Goch was unable to examine any of the points that Mr. Malaud was trying to make in his own defense. Furthermore, the Supreme Court of Michigan clarified in the 1976 case of People v. Anderson that a trial court may refuse or revoke self-representation if it determines that permitting the defendant to act as their own attorney would interfere with the proceedings or unduly burden the court's operations, even in cases where the defendant clearly states his desire to proceed pro se and waives his right to counsel knowingly, intelligently, and voluntarily. As a result, Michigan law acknowledges that a criminal defendant's right to self-representation is limited and may be curtailed if the defendant's actions compromise the impartial and effective administration of justice.
I've challenged this court's jurisdiction. You haven't established it yet. You said you have a statutory jurisdiction which doesn't exist under the Constitution. I'm trying to figure out where I stand with this. So I can't answer any of your questions until you answer some of mine.
That's not how it works. Are you refusing to answer my question?
No, I'm
Then answer it. Do you understand the maximum penalty that you face for this charge?
So judges who become involved in enforcement of
Mr.
these
McLeod,
statutes.
I have other matters. Mr. McLeod,
Involved agency. What's that?
you know, I understand you want to object to things, and you're going to be allowed to object to things, okay?
Sure.
But we have to do things one step at a time. And I do have other cases today. I'm not going to entertain this for like a whole hour. I've got other cases going on. If you want to dig in your heels and just make this real complicated or real difficult, we could do that. And I can hold you in contempt and you'll go back to a jail cell for a while.
Your Honor, I don't wish to be held in contempt. I just wish to exercise my Sixth Amendment right.
That's fine.
And
So before I can let you under,
I can cite laws that will show you that the exercise of a right can be converted into a crime. I'm trying to understand the nature and cause of the action against me. You're not clarifying it enough to where I can comprehend it, as you say.
you can comprehend the maximum penalty that you would face.
I'm not answering any of those questions until you establish that this is a court of the Constitution, has jurisdiction under these jurisdictions.
I established it. I told you. You might think I'm wrong and you can appeal.
There's no such thing as a statutory jurisdiction.
Mr. McLeod, let me make this simple for you. Do you ever watch, let me make this simple for you.
Sure.
I'm going to ask you this question one more time. One more time.
Okay.
Two things are going to happen. You are either going to answer my question or I'm going to hold you summarily in contempt and the court officer will bring you to a jail cell and we'll talk about it tomorrow. You understand that?
So,
Mr. McLeod, Mr. McLeod, two things are going to happen. You're going to answer my question or you're going to jail for summary contempt for not complying with the court's request. Do you, Mr. McLeod, understand that the maximum penalty for the charge against you is 3 years in prison and or $1,000 fine?
I don't understand the charges.
Mr. McLeod is in contempt of court taken into custody.
Really? That's it. Protecting my rights is what this isn't true. You guys are
follow unconstitutional
You're following
orders.
unlawful orders. It's not
Not a
constitutional
good
at all.
thing.
Mr. McLeod's in contempt. He's sentenced to 1 day. Mr. McLeod, your sentence is 1 day in jail. We'll reconvene tomorrow and get you
This is about
notice.
the Constitution. I did nothing wrong except to question and exercise my rights.
Judge Gocha finds Mr. Malaud in contempt of court and condemns him to 1 day in prison when he refuses to respond to his queries. Mr. Malaud continued to represent himself as the case progressed, and his actions grew more disruptive. Ultimately, Mr. Malaud's right to self-representation and his bail were withdrawn by Judge Gocha in July 2024 after he failed to show up for a scheduled court appearance and refused to collect court mail. In September 2024, The case came to an end when Mr. Mloud entered a guilty plea to 1 felony count of impeding and resisting a conservation officer and 1 misdemeanor count of operating a watercraft while intoxicated. He was sentenced to 69 days in prison with full credit for time served. In addition, Mr. Mloud received a fine and had his boating rights revoked for a full year. Even though both of the defendants we saw today choose to represent themselves, there was a stark contrast in their strategies. Ms. Steele was well prepared, courteous, and attentive to the facts of her case when she appeared in court. She was aware of the accusations, adhered to the rules of the courtroom, and utilized cross-examination to highlight contradictions in the officer's evidence. Even though she was defending herself, her composed manner and reasoned questions showed that she appreciated the process. In contrast, Mr. Mloud appeared in court on considerably more severe allegations and used the proceedings as an opportunity to contest the legitimacy of the court. His inability to respond to simple inquiries, his frequent interruptions, and his obsession with jurisdictional disputes demonstrated a lack of knowledge of courtroom protocol and what was expected of him in his self-representation. In the end, his actions compelled Judge Gocher to deny him the opportunity to defend himself, in sharp contrast to Ms. Steele's capacity to remain composed and credible in front of the bench and get a positive decision. These two opposing examples show that while the right to self-representation is guaranteed by the Constitution, using it successfully calls for more than simply assurance or conviction. It requires readiness, deference to the court, and knowledge of the regulations governing the procedure. Monsieur Steele's case demonstrates that when such characteristics are present, a self-represented defendant may win, even in a case with modest stakes like a traffic infraction. However, Mr. Mloud's experience shows how easily things may fall apart when they aren't. If you would want us to discuss a case or courtroom exchange, please let us know in the comments section below. We appreciate you viewing, and please remember to share and subscribe so that we can promote a better informed society.